Hi everyone, welcome to this week's segment of BMS monologues. Um, I'll shift my attention in this week's monologues to politics, and not just politics, but also the law as applied or as proposed for application. Um, as usual, if you like, you can subscribe to the channel, you can like the video, you can subscribe and for future videos as I upload them. So this week's discussion or monologue shall come from the High Court ruling last year concerning the Building Bridges Initiative. I, for one, think that the ruling has significant implications, and I feel that one implication undermines the Constitution. I have a feeling that the application of the basic structure doctrine undermines Article 2 of the Constitution. Why am I saying that? Article 2 of the Constitution talks about the supremacy of the Constitution, that whatever law is formulated and applied, whether customary or in whatever form, ought to be consistent with the Constitution. Now, in the Building Bridges or the BBI case, one thing that was apparent is the importance of understanding the basic structure doctrine. But what really is the basic structure doctrine? Now, the basic structure doctrine is a proposal made by Professor Yanni Rosnai concerning constitutions and constitution making and their amendment. This doctrine was famously used in the Kesavananda Bharati versus State of Kerala case. It's an Indian case that made its way into the Kenyan framework through BBI ruling. It was used as a reference point in stating that the basic structure doctrine applies to the Kenyan situation. So what is the basic structure doctrine? The basic structure doctrine proposes 3 levels of exercising power in amending a constitution, or 3 levels of amendment power. The first level is a complete overhaul of a constitution, which is the primary constituent power. Under the primary constituent power, we have four processes. During the arguments, you will note that the advocates for both sides talked of four sequential steps. They're not necessarily sequential, but they are understood within the primary constituent power framework that you have civic education, you have constituent assemblies, where you have delegates getting involved in the constitution making process, you have public participation, and you have a referendum. So those four processes are to the employ of the primary constituent power. So from that understanding, the sovereign is fully involved in the primary constituent power. It is an exercise of sovereignty by the people in the making of a new constitution. That's basically a new constitution. And the second level of exercising amendment power is the secondary constituent power. In the secondary constituent power, the sovereign again exercises their power through a referendum where they respond to a question or several questions regarding a matter within the Constitution. You can ask a question whether you want the Supreme Court to be scrapped in a yes or no format. Then if they say yes, the Supreme Court is scrapped. If they say no, it is retained. In such formats, you have a yes or no format, or you have that's basically it, a yes or no format, like the referendums we've had before, the two referenda we've had, where in 2005 majority of Kenyans voted no for the new constitution that was built, the workout draft. In 2010 they voted yes, and it was promulgated as the new constitution, and pursuant to Article 264 of that promulgated constitution, the former constitution was rendered repealed. So that was within the framework of the primary constituent power, where you had all those steps, including the referendum, but now in secondary, you have a referendum alone. So the third level of exercise is the constituted power, which is within the employ of Parliament. So Parliament amends the Constitution, exercising constituted power, which is third order. So those are the levels of amendment or amending power that are proposed by Professor Yaniv Rosnai's basic structure doctrine. So the doctrine was applied in the Kesavananda, Bharati, and State of Kerala case. But what business does the basic structure doctrine have to do with the Kenyan constitution? we need to understand first that elements of the basic structured doctrine were contained in the repealed constitution. Because if you were keen in the making of the new constitution, we had constituent assemblies. From those constituent assemblies, proposals were made. We had constituent assemblies in Kilifi. We had constituent assemblies in Bomas. We had constituent assemblies. We had constituent assemblies. That's the point. And from those constituent assemblies, they came up with proposals that were collated into a bill. Then that bill was presented to the public for civic education and to ensure there was public participation. So after that, so you see the civic education and public participation are concurrent in that manner. So after that, there was a referendum that ushered in the 2010 constitution. So the previous constitution understood those processes. So if you were to amend the constitution as we have it, like to do an overhaul, then for some reason you'd summon the primary constituent power. But the question that needs to be asked is this: was the Building Bridges Initiative basically proposing a new constitution, or were they amendments? Were they amendments that were within the ambit of Articles 255 to Article 257? And at what point do you have hyper amendments? What is the threshold to cross into the region of hyper amendments? Do hyper amendments mean an overhaul of the Constitution, such that you have to summon the primary constituent power? These are some of the things that need to be asked. Is there a guiding law on amendments to the Constitution? The answer is there isn't at the moment. But is the existing framework adequate to express itself on how to amend the Constitution, such that if you have amendments proposed to the degree of the Building Bridges Initiative, they are not interpreted as an overhaul of the Constitution or an overhaul to the Constitution? Those are some of the questions that are raised, but did the court answer? Maybe, maybe not. Because when you rule that the basic structure doctrine applies, then you are simply telling the one who subscribes to that ruling that there is a template that guides the Constitution. But what does that do to Article 2? subarticle 4 that states that any law, including customary law, that is inconsistent with this constitution is void to the extent of its inconsistency, or any law, including customary law, that is that violates the constitution is a nullity or void. So what does that ruling do to the supremacy of the constitution? Does it mean that what the constitution has proposed as the process for its amendment is inadequate? And if it's inadequate, is there a law that has proposed a basic structure doctrine such that the courts, in their own wisdom, determined that the amendments that were proposed by the Building Bridges Initiative were hyper amendments, and hyper amendments should be interpreted as making a new constitution? And in that regard, you have to employ the power under the amenability power under the primary constituent power and not the secondary constituent power. Is that what was meant? Is that what should be interpreted to mean in the situation? So, was the court guided by the Constitution, or did the courts legislate? Because there is no law, they legislated on the bench and determined that if there is to be a law, then it should subscribe to the basic structure doctrine, such that the basic structure doctrine informs an act of parliament which is on amendments to the constitution. That when amending the constitution, you have to have civic education, you have to have public participation, you have to have constituent assemblies, you have to have a referendum. Those four processes are understood within that framework of amendment of the constitution. Because if there was an act of parliament that summoned those four processes, then it's a different story. Then it means that it's a furtherance to Articles 255 to 257. Because within the framework of Article 255 to 257, there are those provisions of the Constitution that whose amendment can only be through a popular initiative. When you are changing the system of governance, for one, when you are increasing the term limits of the president, when you are changing the system of the judiciary, anything to do with the judiciary, representation of the people, all those, you need a referendum. They can only be changed through a referendum. That's what the Constitution says. And then The Constitution provides guidance for popular initiative, and it provides guidance for parliamentary initiative. So if there is to be an act by Parliament or an act of Parliament, then the act should just further what has been prescribed in Articles 255 to Article 257. It should be a furtherance. It cannot add or subtract whatever is contained in those articles. It can only an act of Parliament is consistent with the Constitution. It cannot purport to add to the Constitution or subtract from the Constitution. So whatever is proposed in the basic structure doctrine can only be an addition to the Constitution, because the Constitution prescribes how to amend it can be amended, what to do to amend it within the provisions of Article 255 to Article 257. So it means doing more than that is an addition to what it says. So, in my humble submission or view, I think that if the Constitution, or not, if the courts or the Supreme Court rules that the basic structure doctrine applies, the implications for Article 2 of the Constitution, where the Constitution is supreme, will have been violated, because the Constitution prescribes as to how it can be amended and shall be amended. So unless the basic structure doctrine is a universal template or a canon of interpretation of constitutionalism that becomes a reference point for any constitution or for any constitution making process or for any constitution amendment process, is a reference point. Just like if you're ruling on matters of civil case, the two scales that are used